हेलो माय डियर स्टूडेंट्स, कैसे हैं आप सब? अपेक्षा है ठीक होंगे। सो टुडे वी विल डिस्कस अबाउट द पोजीशन ऑफ द प्रेसिडेंट ऑफ इंडिया with the help of certain provisions which are given in the constitution, and there are some polity based on it, right? So if any person wants to contest the election of president, that means election of president is conducted under an electoral college which is mentioned under article 54, and there shall be uniformity of representation of the different states at the election, and there must be the parity maintained between the states as a whole. Secondly, vote of the states in aggregate in the electoral college for the election of the president shall be equal to that of the people of the country as a whole. A person who has 10 proposers and 10 seconders, the presidential and the vice presidential act makes provisions. It was earlier provision, but nowadays near about 50 proposers and 50 seconders are required to contest the election of the president. And if we talks about the system and qualifications of the president, nature and extent of the executive of power of president. So the union cabinet consists of the president and the vice president, and the council of ministers and the attorney general of India under Article 52 provides that there shall be a President of India. The executive power of the Union shall be vested in the President and head of the state under Article 53. All executive functions are executed in the name of the President. Authenticated. If we talks about the authenticated, what does that mean? All executive functions are exercised in the name of the president, authenticated in such manner as may be prescribed by rules to be made by president. Position of president. If we talks about the position of president, relation between the president and the council of ministers, the president must exercise the power according to the constitution. Article 53 clause 1, which vests the executive power of the union in the president, provides that the power may be exercised by the president either directly or through officers subordinate to him. So for this purpose, ministers are deemed to be officers subordinate to him. According to the constitution, article 74 clause 1 provides that there shall be the council of ministers with prime minister at the head of its aid and advise the president in exercise of his functions. So article 74 clause 2 says that uh, the question whether any, and if so, what advice has been tendered by the ministers to the president shall not be inquired into any court. Thus, relation between the president and council of ministers are confidential. Prior to the 42nd Constitutional Amendment Act, there was no clear provision in the constitution that president was bound by the ministerial advice. This amendment, 42nd Constitutional Amendment Act, make an amendment under Article 74, which makes it clear that President shall be bound by the advice of the Council of Ministers. However, by 44th Constitutional Amendment has been given one's chance to the send back the advice to the Council of Ministers for reconsideration. Here, one thing I want to clear that in the Constitution of India, there are two places where the president has power to send back the matters. First, under Article 111, if any bill passed by the both houses of parliament and sent to the president for his assent, so he has power to assent that bill, or may withhold his assent to the bill, or may return the bill for reconsideration of parliament. So I am not talking that position here. under Article 74, there was a proviso inserted by the 44th Constitutional Amendment Act. President has given one chance to send back advice to the Council of Ministers, right, for the reconsideration. However, President shall act in accordance with such advice. Whatever the advice given by the Council of Ministers, the President is bound to give the President is bound to act according to that advice. However, President shall act in accordance with the advice tendered after such consideration. Article 75 clause 1 says that the Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on advice of the Prime Minister. As per Indian constitution, if it talks about the appointment of prime minister, so the prime minister will be appointed by the president, but it is not clear to whom the president is going to appoint as a prime minister. So president has wide administrative power to appoint or dismiss the officers, ministers, whatever, and military powers and the diplomatic power, legislative power, so on. So Article 73 provides that executive power of the union shall extend to the matters with respect to which Parliament has power to make the laws and includes the exercise of such rights, authority and jurisdiction as are exercisable by the government of India. So by virtue of any treaty or agreement, if there is provision to do that thing, the president is empowered. Thus, the executive power is coextensive with the legislative power of the union. I want to just clear it that whatever the legislative power of parliament, that will be the extent of the executive power of the president. As per Article 75 subclause 2, it says that the minister shall hold office during the pleasure of president. And Article 75 clause 3 says that the council of ministers shall be collectively responsible for the Lok Sabha. So here these two principles are very important to decide the position of the president. First, the minister shall hold office during the pleasure of president. So here a question arises that if president wants to dismiss any minister from any ministry, can he do so by his own will? So no, until and unless the prime minister will advise the president to do so, he can't do that. Secondly, the prime minister and the council of ministers are responsible towards the Lok Sabha. So collective responsibility implies that the council of ministers is responsible as a body for the general conduct of affairs of the government. So if no confidence motion is passed against any one minister, the entire council of ministers must resign. Remember it for the prelims examination also. If a no confidence motion is passed against any one minister, the entire council of ministers must resign. Clause 1A added to the Article 75 Clause 1 by the 91st Constitutional Amendment Act 2003, which provides that size of the Council of Ministers, including the Prime Minister, shall not exceed 50% of the total number of the members of the Lok Sabha. So if we talks about the president's discretion and limited one according to the Dr. B.R. Ambedkar, if we talks about the statement of the Dr. B.R. Ambedkar, so he was also the chairman of the drafting committee of the Constituent Assembly. So the president occupies the same position as the king under the English constitution. He is the head of state, but not of the executive. He represents the nation but does not rule the nation. His place in the administration is that of a ceremonial advice on a seal by which the nation's decision are made known. Clear? So he can do nothing contrary to the advice of Council of Minister, nor can do anything without their advice. Alladi Krishna Iyer, a member of the drafting committee of the Constituent Assembly, observed that the word president used in the constitution merely stands for the fabric responsible to the legislature, right? So what he means by the term president is the Union Council of Ministers, which is declared to be collectively responsible to the House of the People, means the Lok Sabha. Executive in the certain marginal classes, President shall has no power to act in the direction in any case. So if it talks about the Council of Minister is responsible to the Lok Sabha, if the president ignores the advice of the ministers enjoying the confidence in the Lok Sabha, it may resign and thus create a constitutional crisis. It is obligatory on the president to have always a council of ministers. Secondly, if he dismiss any ministry having support of the Lok Sabha, they may bring impeachment proceeding against him. This serve as a deterrent against the president assuming the real power. Appointment of the prime minister. If it talks about the appointment of prime minister, president decision is limited. Thus, when a single party gains an absolute majority, has an accepted leader, president's choice of the selecting the prime minister is a mere formality. Similarly, if one of the death or resignation of the prime minister, the ruling party elects a new leader, president has no choice but to appoint him as prime minister. However, if no single party gains absolute, or you can say workable majority, and coalition government is to be formed, the president can exercise a little discretion and select the leader of any party who is in opinion can command the support of the majority in the Lok Sabha and form a stable government. If we talks about the Shamsher Singh's case, that was the decision of the Supreme Court. However, even in such a situation, that means case of the hung parliament, the president action is guided by the certain governance, or you can say certain parliamentary conventions. First, if it talks about the convention, in the case of the federal of ruling, of which talks about the defeat of the ruling party in the lower house by a no confidence motion, the president should invite the leader of opposition. Secondly, where none of the parties has attained absolute majority in the Lok Sabha, the president may invite the leader of the people largest party to form the government. Thirdly, if two or more parties form a coalition before the election and secure the suitable and you can say absolute majority in the election, the leader of such a coalition should be invited. Fourthly, the president should invite leader of the coalition or alliance formed after the election. If it talks about the discretion of the president in case of the dismissal of the ministry, so we talk about it also, but later on in the next chapter we will discuss about the dismissal of the ministry. Thank you so much.